Thanks, Mr. Chairman. Let me say at the outset, Mr. Chairman, thank you for the way you've presided over this committee. It's been a challenge for the last several days, but you and I have been through battles in the past, both as allies and as enemies, and you've always shown fairness, and I appreciate the fairness you've shown during the course of this hearing. I also want to say a word about the protesters who've interrupted the hearing from time to time. As I said at the outset, this is one of the costs of democracy, and it's one which the Senate Judiciary Committee, which has been constructed for the purpose of guarding our Constitution, should value even when it's inconvenient. I could go into a long riff here, but I won't in the interest of time. But I don't know who organized these protests or why they did it, but thank goodness in the United States of America, where we venerate free speech, these things can happen. I want to thank the men and women of the Capitol Police and those who have been in charge of our security during this period of time as well. I would like to also ask for two things to be entered into the record. First is record statements in opposition to the Kavanaugh nomination from several groups with
Without objection.
Thank you very much. And secondly, Senator Grassley closed the earlier last session with some comment I'll have to read in its entirety to understand, but I think he said, or someone said, it would take 37 weeks for the National Archives to go through Judge Kavanaugh's record. I'd like to enter into the record a letter from August 2nd, 2018 from Gary Stern, General Counsel of the National Archives, which concludes with the following statement. By the end of October 2018, we would have completed the remaining 600,000 pages that we should be considering and unfortunately cannot. So I'd ask consent to enter that letter into the official record.
Without objection.
Thank you very much. Judge Kavanaugh, I remember when I got my results from my bar exam, I thought to myself, well, that'll be the last time I ever have to sit down and take an exam. So at the end of this day, this may be your last formal exam in terms of your legal career, and I'm sure there's a sense of expectation, hopefulness, and relief in that. I want to thank your wife for being here and for bringing those beautiful daughters. I hope someday they will understand what happened to their father in a few days here. But thank you so much for being part of this hearing. Judge, when I started this, I said, this is not just about filling a key vacancy on the Supreme Court, a deciding vote on the court, a vote which may decide life and death issues on important cases. It's more than the question of release of documents. It is really goes to the heart of where we are in America at this moment. You have been nominated to be a justice on the United States Supreme Court by President Donald Trump. We have to take your nomination in the context of this moment in history. We're in a moment where the president has shown contempt for the federal judiciary, unlike any president we can recall. He has shown disrespect for the rule of law over and over again. He has repeatedly ridiculed the Attorney General of the United States, whom he chose. He has called for blatant partisanship in the prosecution of our laws. He is a president who is the subject of an active criminal investigation, an investigation which he has apparently sought to obstruct repeatedly. He is a president who has been characterized in this hearing publicly on the record as an unindicted co-conspirator. And in the last 2 days during the course of this hearing, there have been two incredible events, the release of a book and an article in the New York Times, which remind us again what a serious moment we face in the history of the United States. And that's why your nomination is different than any. I can't recall any that have ever been brought before us in this context. I can't recall so many people across the United States following this as carefully. Perhaps Clarence Thomas. At that time, everybody in America was tuned in. But it's in the context of the Trump presidency that we ask you these questions, in anticipation that you may face issues involving this president, which no other Supreme Court has been asked to face. And that is why I want to address your view of the power of this president, the authority of this president, because it's an important contemporary question, which of course has application far beyond his presidency. You've quoted me several times, thank you, yesterday regarding the independent counsel statute. As our Republican colleagues are fond of reminding us, judges are not legislators. So to state the obvious, my opposition, or any legislator's opposition to reauthorizing a statute is very different from a judge's opinion on whether a statute is unconstitutional. To get to the heart of the matter, the reason why we continue to return to the Morrison versus Olson decision is because of its significance in light of the Trump presidency. The reason we're so interested in your view that that case was wrongly decided has little to do with the statute that was in question. It has everything to do with your views on the power of the executive and what that would mean for this president and future presidents if you join the Supreme Court. Justice Scalia's Morrison versus Olson sole dissent embraces the so-called unitary executive theory, which grants sweeping powers to the President of the United States. Scalia said, and I quote, "We should say here that the President's constitutionally assigned duties include complete control over investigation and prosecution of violation of law, and that the inexorable command of Article 2 is clear and definite. The executive power must be vested in the President of the United States." In this age of President Donald Trump, this expansive view of presidential power takes on added significance. Earlier this year, the Senate Judiciary Committee reported a bipartisan bill to protect the independence of the special counsel, Bob Mueller. Several Republican senators who are here today cited Scalia's dissent to justify their opposition to a bill protecting this special counsel, with one even saying, and I quote, "Many of us think we are bound by Scalia's dissent." At the time, I joked and said, instead of dealing with stare decisis, we're dealing with Scalia decisis. Given your views on Morrison versus Olson, we are obviously worried that you will feel bound by this dissent by Anton Scalia if President Trump decides to attempt to fire the special counsel, Bob Mueller. It doesn't stop there. You cited Scalia's dissent in the case involving the Consumer Financial Protection Bureau, where you gutted that agency. And in the 2011 Seventh Sky case, you dissented from a decision upholding the Affordable Care Act and made a breathtaking claim of presidential power, which has been repeated over and over again. And you said, under the Constitution, the president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. Your words. Of course, the unitary executive theory was the basis for President Bush's December 30th, 2005 signing statement claiming the authority to override the McCain torture amendment. Yesterday, I asked you what comments you made on the signing statement as President Bush's staff secretary. Senator Feinstein asked a similar question this morning. What you told me was, I can't recall what I said. I do recall there was a good deal of internal debate about that signing statement, as you can imagine. I do remember it would be controversial internally. It's hard to imagine you can't remember that controversial issue. Given our concerns about your views on executive power, it's important for you at this moment, please, to clarify for us the power of the presidency in this age of Donald Trump.
Senator, thank you. First, thank you for your comments about my wife and daughters. My daughters will return this afternoon for return engagements, so they'll experience democracy once again in action, and I appreciate that. On Morrison versus Olson, a couple things at the outset. First, that case did not involve the special counsel system. I have written repeatedly that the traditional special counsel system, which we have now and have had historically, is a distinct system appointed by the Attorney General. Morrison has nothing to do with that. That dealt with the old independent counsel statute, as you said, which has expired in 1999 under overwhelming consensus that that statute was inappropriate, unrestrained, unaccountable, as you said. Secondly, Morrison, Justice Scalia's dissent, that does not affect the precedent of Humphrey's executor. Humphrey's executor is the Supreme Court precedent that allows independent agencies to exist. Those independent regulatory agencies continue to exist, of course. So both on the independent agency side, those are unaffected. On the special counsel side, that's unaffected. You mentioned the CFPB case. My decision in that case would have allowed that agency to continue operating and performing its important functions for American consumers. The only correction would have been in the structure, because it was a novel structure that was unlike every other independent agency that had been created previously. As to the concept of prosecutorial discretion that's referred to in the 2011 case, that is a traditional concept, prosecutorial discretion, that's recognized in the executive branch. The limits of it are uncertain. That's arisen in the immigration context with President Obama. There's debates about what the limits are. Those are not finally determined, but the basic concept of prosecutorial discretion is all I was referring to there. I've made clear in my writings that a court order that requires a president to do something or prohibits a president from doing something under the Constitution or laws of the United States is the final word in our system, our separation of powers system. That's Cooper versus Aaron. That's Marbury versus Madison. That's United States versus Richard Nixon. That is an important principle. And finally, I would say that the question of who controls the executive power within the executive branch, the vertical question, you have the president at the top, you have independent agencies which exist consistent with precedent, is distinct from the question of what's the scope of the executive power vis-a-vis Congress. On that latter question, the scope of executive power vis-a-vis Congress, I've made clear in the context of national security, the Youngstown framework, context of administrative law, my cases questioning unilateral executive rewriting of the law, in the criminal law, where I've reversed convictions, that I am one not afraid at all through my record of 12 years to invalidate executive power when
Judge,
it violates the law.
let me ask you this, because you've referred to Judge Youngstown case in the context of a war and a decision by a president that was immensely unpopular.
Yes.
And the decision, or might have been popular, I should say, and the decision of the Supreme Court, which could have been very unpopular at that moment in history. What I'm trying to ask you is an historic context. Do you understand where we are as a nation now? When books are being written about how democracy dies, when fear of authoritarian rule and the expansion of the executive branch is rampant in this country, when illustrations of it are found around the world, why we are asking you over and over again, give us some reassurance about your commitment to the democratic institutions of this country in the face of a president who seems prepared to cast them aside, whether it's voter suppression, the role of the media. Case after case, we hear this president willing to walk away from the rule of law in this country. That's the historic context which this is in. Not a particular case, but a particular moment in history.
Sir, my 12-year record shows, and my statements to the committee show, and all my teaching and articles show my commitment to the independence of the judiciary as the crown jewel of our constitutional republic. My citing of Justice Kennedy, for whom I worked, who left us a legacy of liberty, but also a legacy of adherence to the rule of law in the United States of America. No one's above the law in the United States. That's a foundational principle that I've talked about, coming from Federalist 69, coming from the structure of the Constitution. We're all equal before the law in the United States of America. And I've made clear my deep faith in the judiciary. The judiciary has been the final guarantor of the rule of law. As I said in my opening, the Supreme Court is the last line of defense for the separation of powers and for the rights and liberties guaranteed by the Constitution and laws of the United States.
You see, that's why the unitary theory of the executive is so worrisome. What you have said is what I want to hear from a co-equal and very important branch of our government. But what you have said in relation to Morrison suggests the president has the last word.
I have not said that, Senator, and I'll reiterate something I said a minute ago, coming from Cooper versus Aaron, coming from Marbury. When a court order requires a president to do something or prohibits a president from doing something under the Constitution or laws of the United States, under our constitutional system, that is the final word.
Let me ask you one last time the question you knew I'd ask about your testimony in 2006.
Yeah.
I'm just struggling with the fact that when I asked you about this issue of detention, interrogation, and torture, you gave such a simple, declarative answer to me and said that I was not involved and am not involved in the questions about the rules governing detention of combatants. We have found at least 3 specific examples where you were. 3. Your discussions about the access to counsel for detainees, your involvement in the Hamdi and Padilla cases, and your involvement with President Bush's signing statement on the McCain torture amendment. Judge Kavanaugh, you say that words matter. You claim to be a textualist when you interpret other people's words, but you don't want to be held accountable for the plain meaning of your own words. Why is it so difficult for you to acknowledge your responsibility, your response to the question, and acknowledge that at least your answer was misleading, if not wrong?
Senator, you had a concern at the time of the 2006 hearing, which was understandable, whether I had been involved in crafting the detention policies, the interrogation policies that were so controversial, that the legal memos had been written in the Department of Justice that were very controversial. As you know, and as the committee knew then, 2 judicial nominees to the Courts of Appeals had been involved in working on some of the memos related to that program. Senator Feinstein led the Intelligence Committee investigation of that matter, produced a massive report, large unclassified report, and apparently an even larger classified report. The Justice Department Office of Professional Responsibility produced a long report about all the lawyers who were involved. I was not involved in crafting those policies.
Do you deny being involved in the 3 specific areas involving detention and interrogation, which I've just read to you? Do you say that you had nothing to do with the Hamdan and Padilla cases, that you weren't involved in the conversation about access to counsel for detainees, that you weren't involved in President Bush's decision on the signing statement on the McCain torture amendment? Are you saying that none of those things occurred?
Senator, what I've made clear is I understood your question then, and I still understand it now, and I understood my answer then, and I still understand it now to be about those legal memos. I was not read into that program. I was not involved. My name does not appear in Senator Feinstein's report, which is...
That's not the question I asked. Do you deny the 3 specific instances where you were involved in questions involving detention and interrogation?
That was the question that I saw that you asked at the time of that hearing, and my answer was then and is now, as Senator Feinstein's report shows and as the professional responsibility report shows, I was not read into that program.
That is not, I didn't ask you about that program.
Okay,
I asked
with
you
your
about
current
the 3
question-
specific instances.
The current
You
question...
keep answering, oh, I wasn't, Feinstein
Yeah.
is my defense. She came to my rescue. She was talking about something else. I've asked you about 3 specific instances where we have written proof and sworn testimony from you now that you were involved in these 3 things, and all of them relate to detention and interrogation, which you gave me your assurance you weren't involved in.
Senator, I'm going to distinguish 2 things. One are what you were asking me in 2006, and my testimony then was accurate and was the truth. What you're asking me now is, for example, on the signing statement, as we discussed in your office, I made clear that, of course, as staff secretary, everything that went to the president for a 3-year period with a few covert exceptions would have crossed my desk on the way from the counsel's office or the policy advisor or wherever it was going, and would have made its way to the president's desk, and that includes that signing statement.
Well,
So-
let me just close. I don't think the staff secretary to the United States president is a file clerk.
Right.
What you have explained to us over and over again, this was a formative moment in your public career. You were giving constitutional issue advice as well as making substantive changes in drafts that were headed for the president's desk. And one of them involved John McCain's torture amendment. And that, to me, is involved directly on detention and interrogation. And I think, unfortunately, your answer does not reflect that.
If you want to speak to that, then we'll go to Senator Lee.
I just wanted to close, Mr. Chairman, by thanking Senator Durbin, and in response to his questions about the judiciary, the role of the judiciary, he gave me a book when we met, biography of Frank Johnson. And that Friday night, after a lot of Senate meetings and a lot of practice sessions, I went home, read the whole thing, and I appreciate it. It's a good model of judicial independence. It's a great story about someone who was a judge in the South in the civil rights era who stood firm for the rule of law, and so a good model. And I thank Senator Durbin for giving me the book.
Well, I thank you.
Senator.
If I just say one word, thank you, Judge Kavanaugh. And that night, obviously, the Nationals weren't playing.
Yes.